To kick off our topic, I would like to share with you, in case you haven't actually read it, the League's declaration, a portion of the League's declaration that we are in a constitutional crisis. Can you hear me okay?
No. You need to speak up.
Okay, I'll speak up and I'll even get closer. So this is from the press release from the League's president and CEO. The CEO, Selena Stewart, and the president, Diana Wynne. And among many things they've said, it's now been 87 days since the start of the Trump administration. From the flagrant disregard for congressional authority and governmental checks and balances, to defying Supreme Court orders to bring Kilmar Abrego Garcia back home, one thing is abundantly clear. Our country is in a constitutional crisis. End of quote. So, we've not faced this kind of thing before, so there's no, dictionary definition of constitutional crisis. So we know that different folks take different views on it. And so we're going to hear from an expert, one of our many experts today. And so go ahead and introduce.
So I'm Ramsey McGowan. I'm glad to see everybody too. We're going to do a very brief introduction because you have a bio printed out for you. I will just reiterate what Becky just said, that the League of Women Voters of the United States has declared a constitutional crisis based on what they see as fundamental assaults and threats to the foundational principles of our democracy, including checks and balances and the rule of law. But this is a complicated issue and it requires some thought and analysis. And that's what we're hoping our program today will help you do, to sort of understand for yourself what the issues involved are. At the League of Women Voters, we pride ourselves on being nonpartisan and taking stances based on analysis and thoughtful consideration, and that's what we hope today will facilitate for you. Analyzing what the issues are, and we as a league support the U.S. declaration that we are in a constitutional crisis, but there are many things to consider as you adopt that point of view. So you have received a handout, both with the bio, but you also have a quiz. We didn't want you to actually try to work through it. It's too many. But we hope it will stimulate you to identify one or two of the issues that then you might want to write a question on the card, so that after our presenter gives his introductory information and framing of some of the issues, then we will go to looking at your questions. And as he finishes up, we can pass the questions down on cards and we'll pose them. So, Mark Fulks, we certainly appreciate you being here.
I always like to hear the applause at the beginning because I never know if it's coming at the end. I think in my bio you probably see that I work at East Tennessee State University now, and I do. They don't let me speak on their behalf. The opinions are mine and mine alone to the extent that they are expressed, and I'm always happy to discuss my opinions and my beliefs. Generally in the lawyerly context, I'm very straightforward, try to be as matter of fact as I can in these times and in certain issues. There's certainly a lot going on, and that sometimes is a little hard to do. As a lawyer, you do end up picking one side or the other at some point. And I will add that working in higher education right now, the constitutional crisis that I experience every day may be a little bit different than the ones you all experience. So, but I'm happy to be here. And in preparing for this, I actually learned a lot about the subject myself. So what is a constitutional crisis? I found this little cartoon from CNN that shows a diagram of the functioning balance of power versus what it looks like when there is a constitutional crisis. So what is exactly a constitutional crisis? As Becky said, there's not really, this is not a legal term. This is not when we study constitutional law in law school, when I teach constitutional law at ETSU to my undergrads, we never talk about, well, what is a constitutional crisis and when does it exist? I did find a definition, however, on the internet. I think it's drawn from Wikipedia and various sources. And I present this to you only for purposes of putting my comments into some type of context. You may have a different definition. The more I look at it, I may come up with a different definition in the long run, but I thought we needed a good starting point. And this one, it's a pretty broad definition. A constitutional crisis occurs when the Constitution fails to provide a clear resolution to a political conflict or when government branches clash, potentially breaching the system of checks and balances. There are several ways this may happen. Ambiguity in the Constitution. The courts have been called upon to interpret the Constitution thousands, if not tens of thousands of times since it was written. It is imbued with ambiguity, so we do have a lot of issues in that regard, and we'll see that with one of the issues I picked out to talk about. Political infeasibility is another one. Defiance of constitutional norms. Those are three. The implications are administrative paralysis. The government may just not work. In recent decades, I guess, you can recall how many times there have been threats to shut down the government with battles between the executive branch and the Congress. That leads to potential administrative paralysis. Budget hearings, the budget is a constant source of administrative paralysis. Loss of legitimacy is also a big issue. When we go through these cycles, people start to question the validity of the government. And also, worst case scenario, civil unrest or conflict. And when you started researching this topic a little bit more, obviously the one very obvious constitutional crisis that this country went through was the Civil War. And they talk about it in dealing with other countries as well, have gone through the same types of things. That's the worst case scenario. So that sort of hopefully gives us some context. These are the fundamental principles of our government. Popular sovereignty, the power ultimately comes from the people. That is one, in my view, that is most often overlooked or disregarded, or it's kind of like an afterthought. If you go back to the cartoon I put up, the people did not appear in that cartoon. Everybody focuses on the three branches of government, but ultimately the power belongs to the people. At the federal level, it's limited government. There are separation of powers. The three branches exercise different realms of authority. There are checks and balances. Each of the branches has a check on the other ones. Federalism is not really implicated in what we're talking about today, but that's the relationship between the states and the federal government. Then we have the rule of law, which is a big one. Always, if there's a conflict anywhere, the rule of law is implicated. And then we have individual rights. So this is what I've put together, how I conceive of the feedback loop, as I call it. And you see, just like the diagram, the Congress, the Supreme Court, and the President are co-equal branches. I put them in the middle because that's where a lot of the conflict usually relies. On the exterior, that's where I put the people. You have to have the people in the conversation. Every 2 years, if the people aren't happy with the government, they can change it. All of the House of Representatives is up for election every 2 years. 1/3 of the Senate is up for election every 2 years. Every 4 years, if the people are not happy with the government, they can change the president. And then every 6 years, That's when your individual senators are up for election. So I think it's important to keep it in that context, because that's how you know the power belongs to the people. We have a built-in structure to regularly rebuild our government. Could be from the ground up if we wanted to. 435 members of the House of Representatives, they all can be tossed out in 2 years, or every 2 years. The Senate's a little bit harder. The Senate is designed to provide long-term stability, so we can only throw a third of them out every 2 years. So if you want, I mean, people who are happy with it, re-elect your own representative. And we know people tend to like their own representative because they tend to remain in power. So that's any conflict. I like to review it with all of these players in mind. Is it a very, very serious constitutional conflict such that might end in a civil war? Well, look, are all the players doing what they're supposed to be doing? Or are they using those, taking advantage of what power they have? This is just a list of the various checks and balances that exist. The president can veto any bill that the Congress enacts. He appoints judges in particular, and senior level people in the executive branch. The president is charged with enforcing the laws. The president actually proposes the budget. All of those things are very, very powerful. Because if the president thinks the courts are running wild, like our current president likes to say, when the budget gets proposed, he can cut their resources. And that is something that over the years has been threatened by various presidents. The courts, their big realm of power and check is that they decide what the Constitution actually means. So anything that the executive branch or the Congress do, the courts can say that's inside or outside the constitutional power. Any laws that they pass can be declared unconstitutional. Any executive actions may be declared unconstitutional. And then I've got Congress on the end. They enact the laws. They pass the budget. They may override the president's vetoes. They are there to confirm the president's appointments, and they may remove judges and justices and also members of the executive branch through impeachment. So that's sort of the playing field that we are on. So I thought I'd look at the current controversy, and this I've really focused on the things that the National League of Women Voters has been saying. 60 days in, they saw lots of problems and said, look, this is an assault on democracy. Some of the things they pointed to: pardoning the January 6th perpetrators, terrorizing immigrant communities, dismantling crucial government agencies, flouting court rulings, reiterated that then at 87 days, flagrant disregard for congressional authority and checks and balances, defiance of a Supreme Court order, particularly to bring Mr. Garcia back to the United States, and then various threats against checks and balances, the rule of law, and free and fair elections. Then 100 days into the administration, the League of Women Voters started the Unite and Rise initiative, which seeks to engage and mobilize 8.5 million voters. See, the League of Women Voters gets it from the diagram. That's the people. You mobilize those people, that's how you can change things and avoid the constitutional crisis. The League of Women Voters, I would add though, is not alone. I'm a lawyer in the legal profession. Many bar associations, the American Bar Association, which is the largest nationwide association, has issued statements in defense of the judiciary and on the issue of the rule of law in particular. Local bar associations, other smaller national bar associations have as well. And you can't read the news these days without something commenting on the existence of a constitutional crisis for any one of a number of reasons. One of the most talked about, I think, that I have seen and the League of Women Voters identified it in particularly as immigration and the rule of law. The Trump administration has done a lot of things in this particular area. It ranged from, reinstituting the building of the wall, deploying the military to assist, increasing detention, increasing expedited removal, ending use of the CBP-1 app and various parole programs. Those parole programs allow illegal immigrants to be released pending their hearing. So they've also acted in the area of asylum and refugee programs, and there's also various interior enforcement mechanisms. In the area of higher education, we saw this with a lot of our students who are actually here. They can't enroll in ETSU if they are not in the country lawfully, or at least if we know that they're not in the country lawfully, we're not allowed to admit them. So the ones that we are aware of are all on a visa. But the administration also started acting very aggressively against those student visas and started revoking those. It did impact our campus here minimally. Other campuses in the state were hit a lot harder with the number of students who the government was seeking to revoke their student visas. Now, they have backed off in that regard, and I think the administration has backed off in a lot of regards. Other key areas, limiting birthright citizenship, and also the attack on diversity, equity, and inclusion programs. Now, one thing to keep in mind, most, if not all, of these policies have been challenged in court. The Trump administration has had various degrees of success. They've also suffered a lot of losses. So that will take us to the case of Kilmar Abrego Garcia. I'm going to assume that a lot of you are somewhat familiar with it. Mr. Garcia entered the U.S. illegally in 2012. In 2019, he was pulled over by Prince George's County Police Department. I believe that's in Virginia, and they identified him as an illegal alien and a member of MS-13. The police then, I think they interviewed him, then transferred him over to Homeland Security. And an immigration judge, and this is, I think, one of the key points in how we ended up where we ended. It goes to an immigration judge. The immigration judge did conclude that there was sufficient evidence that he was a member of MS-13 and denied him release on bond. Now, Garcia denies it. His attorneys argue that the evidence, which was from an anonymous source, was not really credible. He's not really a member. So what Garcia also did was he applied for he filed a petition for asylum. He had a major obstacle to come over because when anybody enters the country illegally or even legally seeking asylum, you have 1 year from your entry to actually petition for asylum. He didn't do that until 2019, 7 years after he arrived. So that part, he lost his petition for asylum. But what he was able to do, and this gets to the order that President Trump's administration is accused of ignoring, anytime an immigrant is in the country, if they can prove that they would be persecuted back home, they get what is called a withholding of removal order. And what this really does, it's a very limited form of relief. It prevents the U.S. government from sending the person back to their home country. It does not prevent removal from the United States. But Garcia proved to the satisfaction of the immigration court that if he went back home to El Salvador, he would be persecuted by, I think it was Barrio 18, which is another gang, actually a rival gang of MS-13. But now his argument was that his family had been targeted by Barrio 18 because they had a business and they function a lot like the mafia used to function in this country, If you had a business, you had to pay what they call down there rent to the gang in order to maintain your business. The family story is that he actually came to the United States to avoid that persecution because he had been specifically targeted by Barrio 18 as one of that gang's means of exercising, threatened intimidation over his family. So the immigration court agreed with that and issued an order, said, you cannot, U.S. government, you cannot remove him to El Salvador because in El Salvador he may face persecution. And that was his reason. More generally, the grounds for persecution, run the gamut. It might be religious persecution. It might be sexual orientation persecution. If you're from a country that is a lot more hostile, that, in some countries it still gets a death sentence. It can be political persecution. We see that a lot in times of revolution in various countries. But for Mr. Garcia, it was just the rampant gang activity. So 2019, the Board of Immigration Appeals basically affirmed everything. They agreed the evidence is sufficient to show that he's a gang member, but they also agreed he proved what he had to prove to get this withholding order. And because of that withholding order, the government decided not to remove him from the country. And there could be any number of reasons for that. It's very difficult sometimes to remove somebody to a country that is not their own. It becomes very, very political at that point as to who's actually going to accept that person. So Garcia was released subject to a supervision order. He just had to report back to DHS once a year. On February 6, 2025, one of the first things that the new administration did was declare a list of Hispanic gangs as foreign terrorist organizations based on their human trafficking, based on their drug trafficking, based on the crimes and violence that they perpetuate. So about, I guess, a little over a month later, Garcia was arrested because of his role in MS-13. Now, I went back, I read all the court documents. It appears that that is based on what was proven to the satisfaction of the immigration court. It doesn't appear to me that they're relying on any new information about any criminal activity that followed that initial report. But that's why he got arrested. He was not given notice or an opportunity to be heard before. The government's position is they were just executing the removal order from October of 2019 by placing him on a flight to El Salvador, which they did on March 15th, 2025. So 3 days after his arrest, he was put on that flight for El Salvador. The record in the courts reflects that he was moved around rather swiftly. Arrested in Maryland. I think from there, they took him, he had at least one other stop before I think he ended up in Louisiana, and then from Louisiana to Texas, and it was from Texas that he was flown to El Salvador. So it went very, very quickly. And they didn't tell him, they didn't give him notice or an opportunity to be heard on its decision now to execute the order from 2019. So that resulted in a lot of litigation, and the Department of Homeland Security has acknowledged this was an administrative error. They explained that at some point along the way, the list of people to be removed, Garcia's name appeared on it, but somehow the reference to the withholding order was lost, which doesn't necessarily make it correct. It's kind of like a clerical error. But they have also argued, because he's a member of the MS-13, in its opinion, that he is now legally disentitled to the withholding of removal. So if you're a member of a terrorist organization, you're not entitled to that relief anymore. So the government's kind of made those two arguments. Well, look, it was a mistake. But he's not entitled to relief now anyway. And then, of course, their third argument is we really can't get him back. This case worked its way all the way to the United States Supreme Court. which filed an order on April 10th, 2025, basically affirming everything that the lower courts had said, especially with respect to the fact that, one, you need to bring him back, and two, you need to give him due process. Due process is probably one of the most fundamental principles of rule of law in this country. Now, in legal parlance, it can get complicated, but it really boils down to notice and an opportunity to be heard, which means the government, at the bare minimum, has to tell you what they're doing and why, and they have to give you some opportunity to contest that. And it's clear Garcia never received those benefits. Now, the court did caution, and this also gets into the constitutional crisis area, because the executive branch all along was saying the courts went too far, they're treading on our authority, you know, foreign relations and these things belong to the executive branch, immigration belongs to the executive branch. And the court didn't say that courts couldn't be involved, because they clearly said you didn't give this guy due process. So you need to bring him home because this was your mistake. But it did say, look, yes, the executive branch does have this realm of authority where they are the primary government actor in international relations, and just said to the court, you need to be cautious about what you do. But clearly said, federal government, you need to bring Mr. Garcia home or do what you can to facilitate that. To date, that has not happened, and I think given the definition of a constitutional crisis that we started with, this is clearly a constitutional crisis now. We have the court clearly giving the Trump administration instructions on its legal obligations and on Mr. Garcia's legal rights, and the administration is making various arguments why they don't have to follow that order, or why the order needs to be changed, or why it's impossible for them to comply with that order. I think there's probably a little bit of truth in everything that they've said, but the part about, you know, my opinion is if they can get Brittany Griner out of a prison in Russia, they can get Mr. Garcia out of a prison in El Salvador. To me, that's about how hard are you really trying, and I think that's the way the judges are probably looking at it, even though we know this kind of stuff goes on all the time. And indeed, El Salvador at least released Mr. Garcia long enough that he met with one senator. So that's the case of Mr. Garcia. How am I doing on time? Keep going. All right.
Can I ask a quick question? I didn't come to the meeting, I just saw you guys out there. Really quick, as far as his citizenship, if you look at the court documents again, and I don't know which one, but I thought it was really interesting. I don't know if it's an administrative error on one of the lower courts, but it actually says he's a Guatemalan citizen, not Salvador. So I thought that was kind of an interesting twist on that, if you actually read the court docs.
I saw that too. Yeah,
So I thought that was kind of interesting because what is it, Barrio 18 is actually a Guatemalan. Just thought that if you wanted.
That, well, I did notice that, and I think that gets into one of the points that the Trump administration has made in the U.S. Supreme Court on the birthright citizenship issue has basically been all of this fast action puts burdens on the courts and on that, you know, they're working really quickly. That order was they probably have a case somewhere with a Guatemalan, particularly I think that happened in the district court. But yeah, that's just a clerical error, I think, because everything else I saw said he is an El Salvadoran national, and I think that's what the president of El Salvador said when he's been asked, are you going to release him? He's like, why would I release one of my own people?
Right.
So he went back to that sovereign. And again, to be fair to the Trump administration, they can't force that president's hand. It has to be a lot of negotiation about what they're going to do with those people. Yes.
Okay, that's,
we're gonna let you finish and then we'll do the question.
Oh, okay. So that's everything I have about Garcia. I do have some more that I was going to jump into birthright citizenship, if you want me to cover that. That also seems, Joy's giving me the thumbs up, so that means I haven't run out of time and I haven't said anything terribly offensive. As I always tell people, I'm like, we're all hearing this for the first time. I don't know what I'm going to say either, so I'll be just as surprised as you are. So the birthright citizenship controversy, this one kind of brings two constitutional crises into play. We start with the text of the 14th Amendment, and it says, all persons born or naturalized, that part's easy, in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. All the discussion you hear about birthright citizenship now, at least from the Trump administration, they are saying this subject to the jurisdiction thereof basically means that there had to be a connection to the United States in particular, subject to that. It's a political reference, meaning there had to be some sort of reference. Now, we got the 14th Amendment. They also point out for what it started as a very, very limited purpose. This was about Dred Scott. This was about the Civil War. That decision said blacks can never be citizens. At the time Dred Scott was decided in 1857, there were free blacks living in the United States. There were also some freed slaves already before the Civil War. So Dred Scott actually pulled the rug out from a whole lot of people who had been living in the U.S. as free citizens. So that was specifically designed to be sure freed slaves and free blacks, yes, they're entitled to citizenship, and their children are entitled to citizenship. Now, over time, it's been expanded to encompass more than just the Civil War era. And there is some case law. I think there are 4 precedents that have kind of addressed this issue. I've only had the opportunity to read one of them, and it is the most prominent one, where the U.S. Supreme Court looked at the issue of a child born in the United States to parents who were Chinese nationals, but permanent residents of the United States. So what the court said there was, because this person was born or naturalized in the United States to permanent residence, that person was entitled to citizenship under the 14th Amendment. Now, there is room, in my opinion, and I've had people yell and scream at me this before, but I'm like, it's a very fine line distinction, but it's there. So a lot of people say, the Trump administration's argument is completely frivolous. I don't necessarily agree, but it's a very fine line distinction that they are drawing when they draw it. But the court in that case acknowledged that because of this language about being subject to the jurisdiction thereof, children born in the U.S. to foreign diplomats, the court said, are not entitled to birthright citizenship. Children who are members of Indian tribes who were subject to tribal law were not entitled to 14th Amendment citizenship. Now, the members of Indian tribes subsequently received citizenship by statute, but in this case, the Supreme Court said they don't get it under the 14th Amendment. And then they also looked forward to the issue of children born on ships in U.S. territorial waters. So one of the things so they have clearly we've got ambiguous language in the Constitution, which is one of the factors I mentioned at the very beginning. We've got a Supreme Court decision that has some ambiguity in it as well, and leaves a little room, because these are the 3 scenarios that they saw in the late 1800s. What was not going on in the late 1800s was rampant illegal immigration. We didn't have, and that's probably just as much because we didn't have the immigration laws that we have now as any other reason. That just wasn't really anything on anybody's mind. What the Trump administration came along and did and said 2 scenarios where we don't think the 14th Amendment applies. The mother is unlawfully present in the country and the father was not a U.S. citizen. And when the mother's presence is lawful but temporary, and the father was not a U.S. citizen. So those are the only two issues where the Trump administration said the 14th Amendment doesn't apply. Now, it's two issues that does hit a whole lot of people. 3 federal judges already have ruled that this is likely unconstitutional executive order, issued temporary injunctions and with nationwide effect, which basically the federal government's ability to act on this executive order has been halted. Now, the Trump administration appealed this all the way to the Supreme Court. Now, the only issue, they made a strategic decision. This case was argued last Thursday. So I went on the court's website, I got the transcript of the argument. That can sometimes tell you what the judges are thinking. But the biggest issue is this issue of nationwide injunctions. And this is one of the reasons there may be, and both sides over the last, I think, 4 or 5 presidential administrations have been subjected to, whoever the president, Joe Biden was subject to some of them, Barack Obama was, President Trump has been now, twice. The Trump administration finally took it to the U.S. Supreme Court and said, look, these nationwide injunctions exceed these trial courts' authority. And they gave many, many reasons to support their argument. My reading of the argument transcript, he might actually win to some degree on that argument, which might lift the nationwide effect of the injunction. Because generally speaking, a U.S. district court's authority only extends to its district. So we've got a district court in Greenville that basically covers northeast Tennessee, from Chattanooga to northeast Tennessee. It's a pretty big swath of northeast Tennessee, but that's its authority. When that court if it were to issue a nationwide injunction, it would be issuing an order that has impacts in California and Alaska and Hawaii, really, really far removed from where the court actually is. So that does make it somewhat controversial how the court will rule. I stopped trying to predict what courts do a long time ago. As every lawyer I know has gone into court going, I'm going to win, the facts and the law are on my side. And you walk out going, how did I lose that? It happens. But in these on bullet points, I won't go into all of them necessarily, but just to point out that the Trump administration has identified a lot of reasons, and basically they are saying this is a constitutional crisis in and of itself, because they are one court. Basically the way they phrase it is the government has to win everywhere, but the plaintiffs only have to win in one court, and then they get this nationwide injunction. So it really is kind of disruptive. It probably should have been intended for a more extreme set of circumstances to be operable, but there you have it. The arguments have been heard. Whatever happens here, and again, the Trump administration decided not to raise the issue of birthright citizenship at this juncture, and the court did question them on that because in some cases they have done that. Their answers were more like, well, we just think the lower courts need some time to work these issues out. The justices pointed out that the government has basically lost in every court that it's gone to so far. And I think that was hinting at the fact that at least some justices think you're just trying to delay the inevitable. But I couldn't see a majority of justices tipping their hat one way or the other. I think there's definitely 3 justices who think the administrative order is unconstitutional. The others were a little more, I guess, cagey in their questioning and their comments. But both of those, I thought this was an interesting case when I got into it, because the issue of birthright citizenship is clearly a constitutional crisis, because we have cases from the U.S. Supreme Court. We have a constitutional provision that establishes this birthright citizenship. We're dealing with what appears to be, as I said, a very, very fine line distinction to try and undo the weight of the precedent that currently exists. But then you just juxtapose that with this issue of national injunctions, which is an issue that has been sort of percolating over the years. And I think in their argument to the court, I think they cited 4 of the current justices being critical of the practice. So this is a case where, hopefully we'll get those 2 crises resolved or averted, but then once the U.S. Supreme Court issues a decision, that just throws it back into that good old feedback loop. The court decides, well then, are the president and the Congress going to go along? And if they don't go along, then we stay in the constitutional crisis. But then, again, the people, every 2 years, which it's less than 2 years now, probably, we're a year away. Y'all are the League of Women Voters. Well, where are we at? So
A year from November.
a year from November. Okay, so we're getting closer. You can tell how connected I am to the political scene. Okay, you need to come to my house and encourage me to get out and vote. No, I do vote, but usually it's like the last day possible because I forget about it. Anyway, it's whatever the court decides, then they have to decide if they agree with the Trump administration, that potentially rips citizenship from people who have had it for what they might think 20, 30, 40 years or more. So the court, when they get that issue on the merits, is going to have to decide, if we agree with the Trump administration, what do we do with the people who have been given citizenship already? Do we take it away from them, or do we just make the court they can rule retroactively. They can also limit their decision to operate prospectively only. So there is a lot at issue with that particular issue. But I think it shows that I think in this particular instance, both sides can say this is a constitutional crisis because we've got these courts exceeding their jurisdiction. And then the other side can rightly say this is a constitutional crisis because you're messing with 14th Amendment citizenship. And there are a lot of people in the country who have enjoyed that citizenship for a number of years. That's all my prepared or semi-prepared comments. So I have been asked to comment, I guess, generally on executive orders and how they function. So, historically, executive orders were not controversial at all. This is basically the way that the president has the executive branch. Everybody in the executive branch works for the president, answers to the president. He gets to appoint all the department heads. This is his way to say, this is our enforcement authority. So we can look at that in the area of immigration, because between the Biden administration and the Trump administration, we had two very, very different approaches. So the Biden administration, he could issue an order that would tell everybody in border control and immigration and customs enforcement, our enforcement priority is no longer stopping people at the border. Our enforcement priority is in another direction. Then Trump comes in and his executive order, one of them said, we're going to go back to stopping people at the border. And one of the things was that, first Trump administration, he had to remain in Mexico policy. The Biden administration did away with that by executive order. That's basically managerial discretion. And for the most part throughout our history, that's all they really were. They weren't hitting upon major policy issues. But what a lot of people believe, and I tend to agree with this perspective, is, probably the last, I want to say maybe 20 years, everything has gotten so hyper-partisan and Congress has gotten so reluctant to do anything. And that's kind of, I'm speaking generally, I think it's both sides, that when the Congress won't address pressing issues, presidents, if they think it's an emergency or an issue that really, really needs to be addressed, they will seek to expand their authority and they will push the envelope of what that authority is. And if they're operating within an arena that the courts have never addressed before, it's kind of intentionally picking a fight, because when the president issues an executive order, one of two things can happen. If people think that order is illegal, they go to court and they sue, or the Congress can step in and pass a law that says that either endorses it or does away with what he did. So they've really become controversial only within, like I said, the last probably 20 years or so, where gridlock in Congress has stopped, the passage of new laws. So, and I think to one extent or another, every president has kind of done it. It's like, I've got to look at what authority I have, and I'm going to, and Barack Obama, President Obama specifically said it. We're going to look at the authority that I have, and I'm going to take executive action. And in doing that, he picked his battles. And I'm sure, based on his public statements of what he actually did, there were things where he looked at it and was probably advised, you can't go that far. But he did take some actions that were perhaps pushing the envelope. President Biden did the same thing. President Trump has done the same thing. But I think President Trump has, he's issued far more executive orders. He's taken on far more sweeping issues, and that does butt up against congressional authority. The issue of shutting departments. If Congress has created a department and has funded that department, the president's ability to shut it down is very, very limited. Now, he can control the way it operates within those parameters, eliminating DEI programs. If those programs were not established by statute, that he's probably acting within his authority there. But shutting it down, no, probably not. Firing employees, if it's for just cause, that's probably within his scope. But so that's what their intended purpose is. This is how the president sends instructions to his underlings. They become controversial and constitutional crisis material when the president exceeds his authority. And, again, on the immigration order, particularly as it's seen in Garcia's case, they didn't give him due process, and they're not bringing him back. I think those things exceed the authority and create that constitutional crisis that somehow the system needs to find a remedy for.
And so we have two questions following up on the immigration case and issue. So I'll just go ahead. One member of our audience posed three questions. I'm going to read them all three, and you might see ways they interrelate. Two parts of factual. One is the implication of a decision that the district court orders national jurisdiction. The question is, if district courts cannot issue national injunctions, then won't all the courts be flooded with cases? And as an aside, how many districts are there? And then another question is, has the administration argued for retroactive stripping of citizenship, and what issue is it that the U.S. government is paying El Salvador to keep him in the prison?
Okay, I think the answers are yes, exactly. No, I don't think so. And, back to, the first question, this U.S. Supreme Court hit on that very thing. Because the argument, now there is an argument around that. So, and I don't remember, thank you for putting me on the spot, the questioner, but I don't remember exactly how many. I should know because I teach it to my students at least twice a year. Every state has at least one district court. In Tennessee, we have 3. There are a couple of states who only have 1. So I think the number is I want to say it's in the 110s, but don't quote me on that, even though this will live on Facebook for all eternity. The court commented on that because it's a judicial economy issue. If you have, if one court issues a nationwide injunction, no other court really has to hear the case. If that court doesn't have that authority, then everybody who wants relief from the executive order has to sue. And conceivably, I don't know what the numbers are, but I think that it said something like 4 to 6 million illegal aliens came in under, so that's 4 to 6 million new cases. The courts, we don't have a court system to handle that. But the Trump administration's counter argument is we do have a vehicle called, oh Lord, now my mind went blank. Where everybody can, it's Rule 23 under the federal rules, everybody, class actions, there it is. All of you have been a member of a class action, I'm sure. You get that little postcard that comes in the mail, and it says, hey, this business screwed you, mail this in and we'll send you a $5 coupon. Meanwhile, the lawyers are making millions.
Yeah.
So what the Trump administration's argument was, oh, they can go in and they can, one person can go into court in one district and file a class action that would cover the whole nation. Now, there are procedural problems with that. It's hard to do, it takes time, there are fast tracking mechanisms. But the Supreme Court, actually, they were talking about that very issue. What do we do if we take this vehicle away from these district courts? How do we handle this influx of cases, and what generally do you do? So it's entirely, if they don't go the class action route, then there will be everybody who wants relief is going to have to sue for relief. So that is a potential problem. What was the second question was, as the Trump administration argued for retroactive application, I didn't dig that deeply in it. It is currently being briefed in First, Fourth, and Ninth Circuits. I think there's a fourth one. But the Trump administration kept saying, we fully briefed it in the Ninth Circuit. I didn't go dig that deeply. I don't think they're arguing that. I wouldn't put it past them, but as a lawyer, I think that would probably not be a good tactic, because that, the courts are going to see that the people who have had the benefit of citizenship should not have that taken from them. So I think that would be even, for the Trump administration, a rather extreme position to take. And I don't remember what the third prong
I
of it
think
was.
that covers
Most of it.
One more,
Okay.
just about due process related to immigration, and that is, if a deported immigrant is, well, I'm not sure I get the question right, likelihood of an immigrant being returned actually getting, what do you see as the probability that there's going to be compliance by the executive with the court order or the actual institution of due process in the Garcia case?
There are a lot of things that the administration could do. I mean, Mr. Garcia doesn't actually have to be brought back to the United States for him to be given due process. It's a rather extreme vehicle, but people can be tried in absentia. It doesn't happen often, but like in the criminal arena, you have a defendant and the defendant flees and they can't find him, and then maybe they can't, extradite back from a foreign country. They can have the trial in his or her absence. They could do that as well. I mean, I don't know, I haven't researched all the procedures that would have to take place, but I think, his lawyers probably could go into court and have a hearing where now the burden is on Garcia to prove that he was not an MS-13 member, which is probably would be a hard thing to do. But that could be done even if he's in prison in El Salvador. But that gets to, so they can give him due process. I mean, even if they have to dial up an ad hoc procedure to do that, let his lawyers come in with their witnesses, let them testify, let the judge decide, has he rebutted this finding that he was an MS-13 member? If he has, then he should get some sort of order relating to, his removal being improper. Now, there are probably lots of legal defenses to that, but due process just requires notice and an opportunity to be heard. Well, by now he has notice. Now they just need to put it into a court and let a judge decide. That just is gonna lead to the next problem. In his individual case, if a court hears it and says, yes, he has carried the burden of proving that he's not an MS-13 member, can we then get him back from El Salvador? And what's that vehicle look like? Because that is still, that order does not have extraterritorial effect. That doesn't force El Salvador to release him. We're back into that political mode where, you know, the administration has to go through the State Department to El Salvador and essentially negotiate that release and return. But again, we can get Brittany Griner out of a Russian prison. I don't, because the Russians are not exactly our friends these days, particularly Putin. El Salvador's president is our friend, at least to some extent. So, but again, international relations are a lot like predicting what a court's going to do. They in El Salvador have a very, very hard line approach to gang activity right now. And it's an emergency orders they've been operating under for I think about 5 years now, where if they think you're a gang member, they just throw you in prison, which is very, very harsh, but it has improved circumstances on the ground in El Salvador dramatically. I hope that answers the question.
So moving on from immigration, this one's more about balance of powers. And the question is, if a Supreme Court does rule that an executive order is unconstitutional, what enforcement power would be able to force the executive to comply if they don't?
They don't have any. Yeah. And that's, that's part of the constitutional design where the branches are equal. It really is a system that is built upon the respect of all the members in the system. When you don't have that, now, the enforcement mechanism, then again, the courts don't have one, but the people do. The president's popularity could tank even amongst his own party. Then you've got elections. A year from November, when we have another election, if, all of the Republicans in the House are tossed out and you have 435 Democrats in the House, the president's going to have a wake-up call. Same thing with, control of the Senate. That's the design, the enforcement mechanism in that instance. But the judiciary cannot force the president to do anything. And this is the Trump administration is unprecedented only in scope, not because this has happened. George Washington defied an order of the Supreme Court. Andrew Jackson did it. Andrew Jackson is the one who is apocryphally quoted as saying, Justice Marshall made his opinion, now let's see him enforce it. We don't know that he actually said that, but that was certainly President Jackson's attitude. There was at least one other president who rather famously ignored orders. And a lot of times it's not a big enough issue for it to become notable. But I think that we're in different times now with Twitter and Facebook and Instagram and 24-hour, 7-day-a-week media. Everything is amplified. And I think you add to that President Trump, who is being a lot more aggressive than previous administrations, we end up with a bigger problem. But the reality of it is there's nothing that the courts can really do to enforce their orders, because enforcement goes back to the Trump, to the executive branch. But that's where you look at, again, impeachment is the ultimate remedy, and not following a court order could be treated as a high crime and misdemeanor, and President Trump could have 6 or 7 impeachments under the belt by the end. Who knows?
The question is about Andrew Jackson and his defiance of the Supreme Court and how that played out.
My understanding, I am not an expert on this particular instance, but I have read about it, that he ignored it and it stayed that way. That, the courts had no remedy for it. So whatever Andrew Jackson did just stood. The other president who also did it was Abraham Lincoln. He did it in two different ways, and his actions stood. I think subsequently, one of the instances had to do with habeas corpus, which just recently has hit the news again. President Trump saying, I'll suspend the writ of habeas corpus, which is what President Lincoln did. The courts ordered him to release some people who were being held as prisoners. He refused to release them. We subsequently learned, I think the courts decided, that the president cannot suspend habeas corpus. Congress has to. And I think it was, I don't remember the specifics of the Andrew Jackson circumstance, but it's clear that he did defy the orders and there was no remedy, no immediate remedy to that.
Thank you. Actually, two more questions now. So
Keep them coming.
okay, so one person, getting back to the very beginning, the introduction, when you talked about what things can kind of set up a constitutional crisis, this person wanted to hear more about what's included in the concept of political infeasibility of, I guess, the conflict to resolve it.
Well, so, you know, a lot of the system, if we go back like to my diagram, the feedback loop, you know, everything works both ways. They're co-equal branches. And, you know, that's kind of one of those things that people forget, particularly if you listen to the lawyers. The lawyers are like, oh, you know, the courts are independent. No, they're independent decision makers. That part is true. They are not independent of the executive branch and the Congress. They all work together. So when you talk about political infeasibility, it's one of the, I would relate it back to the Civil War. We had the South wanting to secede from the Union. The Constitution doesn't say anything about that. There was not a statute that said, how does that happen? So everything is about how you join the Union. There's nothing that says you can't even leave. And actually, this U.S. Supreme Court has subsequently said, you can't leave. Once you're in, you're in. It's like the mafia. You know, so I don't know if that's a good analogy, but you know, they say you can never leave.
Be accurate.
So the political infeasibility relates to, you know, sort of all of it. And you know, historically, a lot of presidents, you know, what they have is the bully pulpit and their popularity. That's their biggest sort of hammer, particularly when they go to Congress. And right now, President Trump, he relies very, very heavily on that. It's clear, you're either with me or you're against me. Even if you're a Republican, if you're against me, we're going to run somebody in the primaries. I'm not going to endorse you. I'm not going to help you at all. So while President Trump remains popular enough, then he's more likely to have Congress go along with what he wants. If his popularity plummets, then the senators and representatives can be more likely to say, hey, you don't have the juice that you used to have. So we're not going to follow you on down this road anymore. And then that persuasive cudgel, you know, he loses that. That's part of the political infeasibility. You know, if Congress it's becoming, you know, Congress right now is probably in a perpetual state of political infeasibility. They can't pass anything. They are required to pass a budget every year. The budget is supposed to be divided into 13 different appropriations bills. I don't remember the last time they did that. It's all on continuing resolutions. And the other thing is they now do use budget reconciliation to pass laws instead of going through the actual legislative process. You know, I mean, that's an instance of political infeasibility. I mean, because the process isn't working right when our budget is continuing resolutions and substantive laws are coming out of a Budget Reconciliation Act. There's supposed to be bills introduced in the House and the Senate. They get referred to committees. The committees debate them. They get rewritten. They get debated. Experts come in and testify about them. They have hearings. And then it gets referred to the floor. And on the floor there are debates. And then we get a law. You know, they always say you don't want to watch the sausage being made. But at least at the end, we know we're eating sausage. I don't know what we're getting now. Because the whole process is not working. And neither side or the sides coming together don't really seem willing to make it work the way it's supposed to function. So I think that's part of the political infeasibility. And again, if the government just stops, the executive branch in particular stops obeying court orders, everything kind of becomes political infeasibility.
Good answer.
Last question. Something near and dear to the League of Women Voters. I'm going to read it verbatim, but it has to do with civic engagement. People that are concerned about this particular thing in particular, but just in general. So the question is, if a situation occurs where the Supreme Court rules one way, the executive doesn't obey, and Congress doesn't hold the executive to the ruling, what can citizens do besides peaceful protest and waiting till the next election? What can you do now, I guess?
Well, so, and I don't know if I can go back all the way to my diagram. I actually had this set up. Oops, there it was. Constant feedback. This darkest circle in which they operate is constant feedback. What do? Well, voting, we get there a year from November. But what's the constant feedback? Calling the White House, calling your senators, calling your representatives, being members of the League of Women Voters, all of these groups, whatever your issue is, join the groups that support that issue. Right now, the Second Amendment is being litigated pretty seriously all over the country. And that's an issue. I teach a class at the university. It's an issue I follow pretty closely. Every time the Supreme Court gets a case on the Second Amendment issue, they get about 50 amicus briefs. An amicus brief, for those of you who don't know, it means friend of the court. It means anybody who has an interest in the outcome can file a brief with the Supreme Court that says, this is what we think the law should be and this is why. And on the First Amendment issues are the same. Any First Amendment issue, if you can look these up, go to the U.S. Supreme Court's website, they post the briefs, you can get to them. But I look at this and I'm like, people criticize the court for taking fewer and fewer cases these days, but the number of amicus briefs has skyrocketed. And it's everybody from, you've got the NRA, the Gun Owners of America, you've got the Brady campaign against violence. You'll have people like, in one of them, it was linguistics scholars, English professors. They filed a brief saying, look, grammatically speaking, this is how you read the Second Amendment. And it's groups about violence against women. It's groups that look at school shootings. It's anybody who is operating in that space with firearms policy, violence, crime prevention. They're filing briefs in the Supreme Court. So join one of those groups and become an advocate. And then those briefs are also filed, I think, to a lesser extent in the circuit courts. And the circle of people who work in those, they're all sort of corresponding and saying, but that's how you get that direct feedback to the Supreme Court. And you can do it in district court. It rarely happens, but it's possible. The circuit courts of appeals, it happens. The president, writing letters, called the White House, again, peacefully protesting outside. I take my daughters to Washington, D.C. every couple of years or so, and every time we go, somebody's protesting somewhere. One of the times was after Justice Kavanaugh had been confirmed. They were protesting outside the front of the Supreme Court building. Same thing with, don't please protest outside their houses. If you want to, you do you, but I think that, in my opinion, undercuts the persuasiveness of your argument. Keep it professional would be my advice. But to some extent, you have a right to if you know where they live. Same thing with Congress and congressmen. Call them, write them, schedule a meeting with them, get your community groups together, speak with them as a community group. While you're certainly entitled to speak to them one-on-one, well, you're not actually entitled, but most of them will, if you're one of their constituents, speak with you one-on-one. If they get an official message from the League of Women Voters or from a church or a civics club or whatever group that you want to put together, you know, and that's the way, you know, all the big lobbying agency groups are so effective because, you know, they've got 6 million members. You know, the National Organization of Women, I don't think they're as big now as they were maybe in the 80s into the mid-90s, are they? But it was always about, they've got X number of members. So when their leader speaks, that leader can claim to be speaking for, you know, 6 million people. So there are countless ways to be engaged politically. You know, write letters to the editor, write op-ed pieces. You know, these days you can set up your own TikTok account and post your own political commentary. I mean, now for this political engagement, there are vastly more opportunities to do that than there used to be. Now, First Amendment gives you the right to speak, doesn't give you the right to be heard, but that doesn't mean you shouldn't try. I mean, you know, I am the issues that mean a lot to me, I'm very active in, and I've joined all of the groups because they are all in various places. That way, you know, I support all of them. So I know that my voice is being heard nationwide because they're doing litigation in California, they're litigating in New York, they bring issues to Tennessee. You know, that's a very important way to do it, especially with the amicus briefs in the U.S. Supreme Court. Now, and if you go out and look, you'll probably see that there's a group you may not be a member of, but there's a group speaking for you on that. But those are all the avenues that are out there. But the most important one to me, and I tell everybody this, right after Trump pardoned all the January 6 people, I had friends that were like, oh, how can he do that? President has virtually carte blanche authority to pardon people. One, learn about civics, understand civics, make sure your friends, family, relatives, everybody in your group understands civics. Because you've got to know, is President Trump the one you want having the pardon authority? Who's he going to pardon? You know, it was controversial when he did it. Some of President Biden's, every president has issued some that were controversial. And yet people always seem shocked when it happens because, you know, and I mean, it makes sense. Nobody really has a big movement out there on pardon power. But, you know, that's a power the president has. We're generally more concerned about bigger things. But that's what I would suggest.
Thank you. And unfortunately, we're close to the end of our time. I want to thank you for an extraordinary amount of helpful information. I want to thank the audience. Questions, we'll be having more programs about democracy and the state of democracy. Maybe we can incorporate some of them into future programs. But thank you so much.
And I want to present you with your card, and thank you so much for coming. This is wonderful. This last question is perfect. I want you to, if you're not signed up for our newsletter, you can find out more about what's going on, the league. Remember, when we speak as a league, we have to be very nonpartisan, and so we will tell you what the league things are, and we are all about peaceful protest. Bob Warner is going to talk to you first about a league thing, an opportunity to help us at the Blue Plum Festival, which is one place we get information out. But now he's also part of another organization. This is not league, but you may find it interesting, but he's going to help you if you want to go out there with these other groups. He's going to help you find these other groups.
Thanks.
Give it just a second.
Thanks. I'll make it real quick. So first thing, a fun thing. Anybody in the room that has been in a booth or tabling or in a parade for the League of Women Voters over the last couple of years? Okay, look at those people. Now talk to somebody next to you and tell them how much fun it was.
Oh, yes.
The League's going to have a booth at Blue Plum Festival right here, right on the grass down there. 6th and 7th of June, and we're still looking for some folks on Saturday, which is the 7th, to be a part of that and help us. We also are probably going to be in about half a dozen parades this year throughout the Tri-Cities, and we're going to do some other things, Tri-Pride and Umoja, and other things later in the year. So we'll announce all that in the newsletter Thank you for making sure folks get on the newsletter, the free newsletter. If you can help out with Blue Plum on the 7th, see me afterwards, and I'll get you a link, get you linked into that. The second thing, maybe a little less fun, is in the categories of other opportunities, not officially a league event, is thank you so much for talking about the Constitution. How many of us have been, if you're behind the camera, so it's okay to do this, put your hand up if you've been exercising your First Amendment right to talk to whoever's listening on the sidewalks of the Tri-Cities in the last, wow, it's a lot of, in the last 6 weeks. So if you don't have your hand up, talk to somebody with their hand up about how important that is to do. So there is now a coalition of 15 organizations. Thank you for mentioning. There are all kinds of organizations to be involved. Just in Southwest Virginia and Northeast Tennessee, there are now 15 organizations that are a part of an alliance, nonpartisan, but are concerned about what incumbents that were voted into office are doing and are doing to us and our fellow citizens. And so we are now, it's called TENVA, T-E-N-N-V-A, United. That's the 15 organizations. And we have a calendar of events. We're planning on doing actions in the Tri-Cities and in Virginia every other week. We just did one yesterday in Kingsport. And there'll be a lot of others as well. So Sharon, if you put your hand up, and John, they both have copies of this. Before you leave, get the website, which we just launched on Thursday. And it will also have the calendar events of not just that which the Alliance is putting together, but all the other organizations, and the League of Women Voters, because we consider them our #1 education organization in this area for these matters. All of those events are going to be on that calendar. So it'd be wonderful to have you join us. Now, exclusively, just because you're here today, I'm going to tell you you need to put July 12th on your calendar. That's one of those 2-week cycles. We're going to have, we have invited our incumbent senator, Marsha Blackburn, to a town hall meeting by the citizens in Jonesboro. We also have invited Gloria Johnson, and Gloria Johnson's coming. We'll see what happens that day. July 12th.
In Jonesboro. And when's your next meeting?
Help me out here, June 22nd. It will be back in Food City, where we usually meet and have a little more room to spread out. There will be a very short business meeting at the start, our annual meeting. If you are a member of the League, you will be getting an email packet within the next week with things like the slate of officers and the budget, all the proposals, because then we're going to go boom, 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 get it done. And Adam Dixon of the Langston Center is going to give us a lovely talk. So we will still have a big program. You are welcome to come if you're not a member. You just can't vote. Okay? Please take some food home with you because we don't want to carry it home. And we will see you next month, I hope.
Thank you.